So changing horses midstream, switching attorneys. Is it something that happens with personal injury cases? The answer is yes. It happens quite a bit. The reasons why people want to switch their attorneys can vary, but most of the calls that I receive come from people who are really interested in switching because they feel that they don't get called back by their lawyers or their assistants, and that there's just a general unresponsiveness to the relationship that they have. That is pretty much the most frequent complaint that I receive from people who are calling to inquire about maybe changing lawyers. There are times people will call and maybe they're just upset with the way the attorney handled a particular issue, or perhaps disagreed very sharply with what the client wanted to do for one reason or another. But most of the time, it's just general unresponsiveness. Now, sometimes there could also be just personality clashes. But when those things come up, whether it be a lawyer who isn't returning calls, or maybe a lawyer who got short with a client who took offense to that, the one thing I always tell people who call, first and foremost, is to set an appointment, meet with the lawyer face to face, and try to work it out. I'm not an attorney who is going to be immediately interested in jumping on a case just because someone had a bad moment or a bad time with their current lawyer. I'm not interested in that. I was raised in a way to act professionally. So when people like this call, the first thing I always tell them, and I mean always, is to make an appointment to try and work it out face to face. I know in this day and age with Zoom and FaceTime, it can be easy just to resort to doing things on a phone call or a video chat, but there is something still to be said for getting in the same room with someone and trying to work out differences, the old-fashioned way. Just try to hash it out, try to work it out, try to remember why you engaged that lawyer in the first place. Maybe you got a great referral from a friend or a family member, and you trusted that person, and that you trusted them so much that you signed up and retained that lawyer. Remember those things and try to work it out. Now, of course, there's not always happy endings to those situations. So what happens after that meeting occurs and the client is still interested in wanting to switch up and substitute an attorney? Does that mean that the client has to pay two personal injury lawyers 2 fees from the same case? The answer is no. And again, I want to be specific to anyone who's watching this on YouTube. I'm a New York State attorney. I handle cases throughout the state, primarily in the Hudson Valley of New York and in New York City. Occasionally, I do have stuff in what's known as the Capital District and even in the Lake George area. But predominantly, my cases are in the Hudson Valley and the New York City area. So the rules and the processes I'm talking about concern things specific to New York State. So when someone is engaged a lawyer previous to meeting with me, they signed a retainer, and most likely that retainer said that the attorney is going to be entitled to a 1/3 share of any amount that's recovered on behalf of the client. And that includes, that doesn't include expenses that the attorney may have already spent out of pocket to prosecute that case. So when people come to me and they've made every effort to try and resolve their differences with their previous lawyer, how do we handle this? What's the process? Well, the client would come in and sign a retainer with me and sign a couple different documents that I would end up sending to the previous lawyer or the outgoing lawyer. And during that process, I would then reach out to the lawyer and ask, to be provided with the disbursements or how much has been spent on the case by that lawyer up to this point. I would then be obligated to reimburse that lawyer. It's just basically like picking up where he or she left off, with the understanding that if there's going to be a recovery made, that there's likely going to be a fee split between myself and my predecessor. And I'm happy to say that in most cases, I can work those things out quite amicably with outgoing lawyers. In fact, there might even be people I know. And that actually just reaffirms what I said at the outset, that it's really important that I stress to my clients that they try to resolve these differences with their lawyers. I don't want to go out of my way to advertise for taking over cases like this. I have no interest in taking food out of my colleagues' mouths. And in fact, I know many of my colleagues feel the exact same way. Not all of them, though. There are many lawyers who would not dispense the advice about trying to work things out amicably before making a switch. There are definitely firms that just take those cases, no questions asked, irrespective of whether or not they know the lawyer or whether or not they have any relationship with the lawyer. I'm not like that. I do not want to make unnecessary waves or create any reputational problems for myself by being considered someone who falls into that category. But they are out there, okay? In any event, after the paperwork is signed and the check is cut for the outgoing lawyer's expenses, then I just pick up where that person left off. I prefer, when encountering these situations, to take on cases that are still in the relative infancy. I am not really interested in taking on cases that are very well developed or advanced. Why? Well, there's a lot of reasons. First of all, you're going to be kind of stuck with the product, if you will, that has already come to pass by the time that person reaches out. There could be any number of tactical decisions that were made by an attorney that maybe I would have done differently. I just don't know how attractive it is to kind of be stuck with someone else's work product. Again, there are other firms that proceed differently and might conduct their business differently, but for me, it's just a preference. If someone comes to me after maybe a few months or maybe a year of being with a firm and the case hasn't been put into suit where a lawsuit was filed and maybe it's still in that claim phase, that's a lot easier to jump in. Nothing has been established in the litigation. There's been no deposition testimony. Most likely doctors that have been treating the clients have been contacted in any meaningful way. Again, I'm speaking generally, of course. So it's a lot easier to style and guide the litigation under those circumstances. Here are my concluding thoughts on the process of someone who reaches out to maybe switch attorneys. Simplicity is the key. If there are minor personality differences that can be worked out between a client and an attorney, I'm going to make every recommendation that client make every effort to make it work. If for some reason that meeting that I recommend just doesn't work out, or there's still bad feelings, then come to someone like myself with as much documentation as you can, whether it be medical records or any other proof that you might need to help establish the case, anything that you can share which would help in the evaluation of the case at that phase is going to be absolutely necessary. I personally don't want to get stuck in a situation where I'm going to be relying entirely on the word of a prospective client. At that point, knowing that person already has an attorney, or at least had one previously, I would need to see the records. You can imagine why. There might be some people who take liberty with the reasons why maybe they don't get along with their lawyer, or maybe there are times where maybe it wasn't a matter of them not getting along with the lawyer. Maybe the lawyer just withdrew from the case for one reason or another. Seeing records will be vital before I can make any definitive decision on whether or not to pick up where a preceding lawyer left off. And there are also business considerations and financial considerations for me to bear in mind here, right? If a preceding lawyer has spent $1,500 or $2,500 or whatever the amount of money it might be on a case up until that point, it could come to pass that lawyer is going to want a bigger share of any attorney fee that's ultimately recovered in the case. This isn't very flattering, but there are times where lawyers actually enter into litigation spatting and feuding and fighting over a fee split. I can tell you right now, judges hate those cases. They never want to be confronted with those cases, but unfortunately, they do happen. I've had that happen once or twice in my 26 years, and it's never a great place to be. It's not the best way for anyone to use their time. But when there are differences between an outgoing lawyer and a present lawyer about how to split up a fee, if push comes to shove, then yes, those things too can be litigated, and that could put the client in a somewhat unusual predicament as well. I thankfully have been able to sidestep any such concerns where clients had to be very, very actively involved in a fee dispute, but it happens, and it can be, awkward to say the least. So again, that is just some of the things that people in my position, as someone who's being solicited to maybe take over a case, would need to factor into any decision. To the people out here who might be watching this, I would just, again, make every effort to make your relationship with your existing attorney work, because that is the simplest way to get to where you really want to go, which is a successful resolution of your case.